the November 8th Ethics Commission meeting. We will follow the tentative agenda. So if I could please ask the city clerk to please call the roll. Okay, Bonnie, sorry.
No problem. Okay, Chair Brian Diener.
Present.
Jerry Felker.
Present.
And Gil Scott.
Present.
Thank you.
Thank you. Seeing this is our first meeting for quite a while, the city clerk will start off by offering the oath of office.
You
Come down there.
You can stand there
okay.
if you want to, or come down.
Okay.
I'm going to give you these cheat sheets here.
Oh, great. Thank you.
Classes worthy.
Yeah. It's a lot of words, that was easier. Okay, you want to raise your right hand. Repeat after me.
We're doing this together, or?
Yes, all together, fine. And then I'm going to say, I state your name, and then you just state your name. I state your name.
I, Jerry Felker,
Do solemnly swear
do solemnly swear
that I possess
that I possess
all the qualifications of an Ethics Commission member,
all the qualifications of the Ward 3 representative for the Ethics Commission
Representing the
sorry,
Ethics
the
Commission.
title is different, as prescribed by law,
as prescribed by law,
that I will support the Constitution
that I will support the Constitution
of the United States
of the United States
and of the state of Missouri,
And of
and
the
the
state of Missouri.
the provisions of all laws
the provisions of all laws
of this state affecting cities of this class,
of this state affecting cities of this class,
and the ordinances of the City of Parkville, Missouri,
And
and the ordinances of the City of Parkville, Missouri,
and that I will faithfully demean myself, so help me God.
and I have faithfully demeaned myself, so help me God.
Sign these forms real quick.
Okay.
This is pen.
Thank you. If I could, just from the chair, before we get to number 4, the city attorney will kind of go over the code of ethics and commission's role. If you guys could please introduce yourself and just maybe tell you how long you've been in Parkville, just so the folks who are watching, this is the first time we've met, and we're down to 3.
My name is Jerry Felker. I've been in Parkville since, I think, 92. Retired pharmacist, retired military.
Thank you.
My name is Gil Scott. Jerry has 10 years on me as a resident of Parkville. I came to Parkville in 2002 and raised 3 children in the Park Hill School District, and this year became empty nesters.
Thank you, Gil. My name is Brian Diener. I've lived in the Northland since '81. When my wife and I became empty nesters, we moved down to the City of Parkville on Main Street about 2 years ago. So, been around, but fairly new to the city itself. So thanks for the introductions. I think if we can ask the city attorney to please go to bullet 4 and give us an overview of what all we're here for.
Thank you, Mr. Chairman. My name is Chris Williams. I do serve as the city attorney for City of Parkville. What we're going to do tonight is go through the Code of Ethics and the Sunshine Law. The Board of Aldermen adopted the Code of Ethics about 15 years ago or so, and it's found in Chapter 107 of the Code of Ordinances. A copy of the chapter is in front of you. Section 107.030 provides that you are to receive orientation training, so that's what we're doing tonight. Like I said, we'll go over Chapter 107 and the Sunshine Law. So let's dive into Chapter 107. The first 107.010 is the purpose and applicability of the chapter and declaration of policy. And I apologize, I'm going to try to summarize as much as I can going through this, but I want to make sure we hit the specific points. So it may get a little long and drawn out, but that's what we got to do.
Good for everybody.
Yeah. The goals as set forth in section 107.010 are that officials and employees be independent, impartial, and responsible to the people. That government decisions and policy be made in proper channels of government structure. That public office not be used for personal gain, and that the public have confidence in integrity of its government. The applicability of that is that Code of Ethics was established and applies to all officials and employees of the city, whether they're elected or appointed, paid or unpaid. So that means The chapter we're looking at applies to you as members of the city's appointed ethics commission. It also applies to you. And the code and commission are established, it says here, in recognition of the goals that we just talked about. And it's the purpose of the code of ethics is to establish ethical standards of conduct for all officials and employees by setting forth acts or actions that are incompatible with the best interests of the city and directing disclosure of private financial and other interests in matters that affect the city. Section 107.020 talks about the responsibilities for those in public office. Officials and employees are agents, it says, of public purpose and hold the office for the benefit of the public. They're bound to uphold the Constitution of Missouri, the United States Constitution, to carry out impartially the laws of the nation, state, and city, to foster respect for government. They're bound to observe in their official acts the highest standards of morality, to discharge faithfully duties of office regardless of personal considerations, recognizing that the public interest must be the primary concern. In conduct in both official and private affairs, it says, should be above reproach. So those are kind of some of the general statements about what the Code of Ethics is and why we have it. Section 107.030, I'm not going to go through where we talk about that. That's the one that says you're to receive training. That's what we're doing. Section 107.040 says fair and equal treatment of citizens and use of city-owned property. Some of these things get a little technical, but that section says it's improper to if somebody's seeking employment with the city, it's improper to canvass members of the Board of Aldermen in order to obtain preferential consideration for employment. If somebody does that, they're disqualified from employment. And then there's a provision that's in this section that says officials and employees shall not request or permit use of city-owned vehicles, equipment, materials, or property for personal convenience or profit except when those services are available to the public generally, or it's provided as a municipal policy for the use of this official employee in conduct of official business. I think what it's talking about there, for example, would be like having an employee use a city vehicle to attend a conference, city conference for official business, just as an example. So that's an exception. Section 107.050, conflicts of interest. That's an important section. It first says that officials, employees must comply with state statutes on conflicts of interest. Those are generally found in Chapter 105 of the Revised Statutes of Missouri, and they, for the most part, they deal with things that involve an official or receiving direct financial benefit or gain to themselves, their spouse, or dependent children, or a business that they may own, or have ownership interest in. And Chapter 105 in the statutes also talks about officials doing business with the city. Some of that is built into the next part of our own code of ethics. Because it says if an official has a substantial or private interest, and that's a defined term, which we'll talk about in a second. So if an official has a substantial or private interest in any measure, bill, order, or ordinance that's proposed or pending before the Board of Aldermen, they must disclose it to the city clerk so that it can be recorded in the minutes of the meeting. Now, the definition of substantial and private interest comes from the state statutes. The one that's in our code is identical to what's in the state statutes. And it's, just so you know, it's ownership by an individual, spouse, or dependent children of 10% or more of any business entity that's involved in some matter with the city. Interest with value of $10,000 or more in the matter, or receipt of salary, gratuity, or other compensation of $5,000 or more from any individual, partnership, organization, or associate within any calendar year, again, for a matter that's in front of the city. I know that gets a little wordy and technical, but that's what the law provides. Another part of the conflict of interest section, elected and appointed officials should avoid the appearance of impropriety by not engaging in conduct that appears to make their decisions influenced by other city officials rather than independently. And then it sets forth a few examples. It says, for example, an official should avoid hiring another member of the same board or commission or committee as an employee. So Brian shouldn't hire Gil. That's what it's saying there. It says you should avoid being hired or retained as an employee by another city official. So an existing city official shouldn't hire one of you. That's the idea there. Shouldn't render financial assistance to another city official, loan money to them, things like that. It's discouraging that. Shouldn't provide another city official with a gift or engaging in any activity where the general public would believe the relationship would have the effect of influencing any decisions being made. That's a pretty broad statement, but that's one of those things that's going to come up on a case-by-case basis, and you just have to take a look at it. The code provides also, if you're unsure, if any official's unsure whether the situation results in conflict of interest, they're encouraged to seek counsel from the city attorney prior to acting. And that does happen. I have folks come to me and say, here's the situation, do I have a conflict? And we walk through the analysis, and all I can do is advise you all, the officials, and it's up to you as to whether you have a conflict. And this is important too. It does note in this section that appearance of fairness and impartiality is as important as actual fairness and impartiality. That's a policy statement. Now, if there is a conflict, somebody actually has a conflict of interest, it says the following steps should be taken. The official must declare the existence of the conflict on the record and that they will not participate in any discussion or action. They have to say that publicly. And on the record means so that the city clerk is taking it down in the minutes, that statement. They shall explain on the record what constitutes the specific conflict, why they have a conflict. They must actually step down from the seats, in your case where you're sitting, and leave the room. We had that happen, I think we had that happen at the last Board of Aldermen meeting, where there was a matter involving one of the council members who worked on a Mid-America Regional Council committee, and the city was doing for hazardous waste disposal, and the city was doing an agreement with them. He got up from his seat, went back in that room and closed the door and stayed there until that issue was done, and then somebody went and got it. So that's how it works. If there's an actual conflict, the official should not speak with any other members during or prior to discussion of the issue that's on the table, and should not represent or speak on behalf of any interested party, but may use a representative to convey their position as a private citizen during discussion of the issue. So I've seen this happen in other cities where there's an elected official, for example, it has a conflict, but they don't give up their right to have their opinion stated to the decision-making body. But what this is saying is they should use a separate representative to speak on their behalf. Because from a practical standpoint, I don't know if that's why they put it in there this way, but from a practical standpoint, if the elected official gets down from there, walks down to here, and starts giving their opinion, it has a different effect. I think that's probably why they did that way. Last thing on the conflict of interest section is must not discuss the issue privately with any other member voting on the matter. So in other words, you just remove yourself from it and until it's over with. Section 107.060 is the penalty and other sanctions provision. And what it says is that if someone violates the code of ethics, it can be a violation of the city's code of ordinances, because the code of ethics is in the code of ordinances. And it provides that they could be fined, the person could be fined from $1 to $100, imprisonment for up to 90 days, restitution, or any or all these pursuant to municipal court proceedings and actions. Just so you know, this penalty provision is the general, it's essentially the same as the general penalty provision for violating anything in the Code of Ordinance book that's about this thick. Some of them have specific provisions for violation, have different penalties, but this is the general penalty provision effectively. I want to say that because people say, wow, imprisonment and all these things. That's not special for this. That's the general penalty across the board. Now, of course, like I said, for some things, traffic violations, of course, have different fines and things set forth. But just if you go through the code book and you see law, the code is the city's laws, and they're violated, that's the general provision, that actually the municipal court judge has the authority to impose those if there's a citation issued. The other penalty provision is described as administrative sanction, which it says is suspension. And remember, we're talking about elected officials, appointed officials, and employees, all three groups in all this stuff. So it says administrative sanction is suspension, removal from office, or employment, or other disciplinary action by the Board of Aldermen pursuant to city ordinances and state statutes. And that part's important at the end, pursuant to city ordinances and state statutes, because the one thing I'd point out is with regard to an elected official, the only thing in the statutes for an elected official's discipline, if you will, for a fourth-class city is impeachment and removal from office pursuant to section 79.240. It's not what you guys would do if you're dealing with one of those situations, but that's talking about what the Board of Aldermen has the authority to do. Now, if it's someone who, for example, an employee that's violating the code of ethics that goes through you, goes to the Board of Aldermen, they could suspend that person, put them on leave, or terminate them, whatever is appropriate that they decide to do. But when an elected official is involved, to my knowledge, the only provision that allows for discipline is the removal from office, kind of an all or nothing type deal. That doesn't mean displeasure with someone's actions can't be expressed, but in terms of actual discipline, there's no authority, for example, to suspend or put an elected official on leave. And you'll see that even in Congress, they'll censure somebody. That's expressing displeasure. But they, unless it's the same deal in Congress, unless they, for the most part, unless they are going to remove them from office, they really can't do a whole lot because they were elected officials put in there by the voters. So. This section also talks about the process here. And one thing it says is that any complaint alleging a violation of code of ethics has to first be submitted to you, the Ethics Commission, for a hearing and advisory determination before there can be any municipal court proceeding and before the Board of Aldermen can take any action for violation of the code of ethics. It has to come through you first if someone's alleging a violation of the code of ethics. Section 107.070, real quick, is just a prohibition on certain elected and appointed officials and employees performing any service for compensation for a year after termination of office by which they're attempting to influence a decision of the city. In other words, no lobbying for a year type of provision for any of those folks. It does not apply to someone who leaves office being compensated for performance of some sort of service if there's an adversary proceeding, a record involved, such as a court process, court case. Or you can leave office and still bid on city work if the RFP structure is that the bid will be awarded to the lowest and best bidder. In other words, if it's competitively bid, then you can participate, even if you left office in less than a year. 107.080, official actions and position. That's getting at no member of the board, commission, or committee, either alone or with other members, should engage in any act which could be viewed by the general public as an official action of that board, commission, unless the action was taken by motion or resolution. In other words, members of these bodies, you can't go out and speak for yourself as if you're speaking for the entire group unless you're conveying something that was approved by motion or resolution. It's actually voted on. And it also says you can't do any written communications that identify conduct as the conduct of the board, commission, or committee, again, unless it was done by a vote. In other words, you just can't go out and represent that you're stating the official position. I don't mean you guys, but the folks involved can't go out and represent that you're stating the official position unless it actually is the official position that was voted on. And if you violate that, you violated the code of ethics. So 107.090, similar kind of thing to some extent. You can't use a municipal board commissioner committee membership for political purpose. If the person participates in any activity on behalf of a candidate for office in any municipal election where the member identifies themselves as a member of the board commissioner committee as a part of the activity on behalf of the candidate, they have to affirmatively state that their activities are in no way sanctioned or connected to the board, commission, or committee that they serve on. Again, they're not speaking for the body, they're speaking for themselves. You know, I endorse John Doe for alderman personally. You know, I'm not saying that because I'm an alderman. I'm not saying the board of aldermen endorsed that person. That's trying to avoid creating that situation or prohibit that situation. Section 107-100. This is you guys, the Municipal Officials Ethics Commission. This is where it sets up the commission and what your powers and duties and things are. So let's walk through that a little bit. The commission, it says, is created with the power and duty to render advisory opinions to the Board of Aldermen in all ethics complaints, to investigate and report on allegations of violations of the Code of Ethics and ordinance provisions regarding conflicts of interest and financial disclosure. It says the commission may call upon the city attorney, city administrator, or other appropriate public officials to assist in investigation, or may utilize outside counsel or staff if it is reasonable and necessary to properly complete its work. We'll talk a little bit more about this later in the agenda, but I want to draw your attention to that with regard to may utilize outside counsel. The commission, and here's a couple important sections. The commission with the concurrence of at least 3 members may issue an advisory opinion upon a written request by a member of the Board of Aldermen, the mayor, or the city administrator. So if there's a request by the mayor, Board of Aldermen, or city administrator for an advisory opinion, if 3 of you agree to do that, then you can issue an opinion. The commission and it says the commission with the affirmative vote of at least 3 members upon a sworn complaint of any resident of the city or upon your own initiative may investigate an alleged violation, so you can investigate and then issue an advisory opinion. If you, again, if 3 of you agree to do that and you so choose to do that, you can do an investigation, issue an opinion. It does say the commission has the power to examine witnesses under oath and can request persons necessary for an investigation if you're doing one, and request that those persons appear before it and produce any records or documents that you believe are relevant. So you have that power. It goes on to say the commission shall, upon receiving any sworn complaint or following its own affirmative vote to consider an investigation, either one of those situations, notify the municipal official in writing of the nature of the complaint. So that's one of the duties you have. And then the municipal official who's the subject of the complaint shall be given at least 10 days to provide the commission with information as he or she deems appropriate to explain or justify the circumstances. So in other words, they can provide a response to you. You have to give them at least 10 days to provide you their response to the complaint, the sworn complaint that you receive. At the request of the municipal official who's subject of the complaint, or on your own initiative, the commission shall hold a hearing where the municipal official can provide evidence and testimony and can examine any other witness that testifies. In other words, essentially a cross-examination. And after all of that, whichever path you go down, at the end, the commission then shall issue its advisory opinion, which can include recommendations. So in other words, as I understand it, the advisory opinion is we looked at a complaint or an issue, and here's our opinion as to whether we think it violates the Code of Ethics or not. And separately from that, you can also include any recommendations. This was a violation that we think is significant. Here's what we think the employee should be terminated, for example. Or this is a minor infraction. We don't think the employee should be terminated. We think that it's more appropriate that they just be recommended. Whatever recommendation you want to make. And the Board of Aldermen can do whatever they want. But, it provides you with the opportunity to hear an motion. And then after you do that, your advisory opinion with recommendations, if you have any, the official who's the subject of the complaint has 5 business days to respond. Any response they want to provide to you in writing. And then at that point, then everything goes to the Board of Aldermen. Your opinion, your recommendations, and their response. And then the Board of Aldermen takes it up and deals with it in accordance with the code. So the makeup of the commission is in 107.110. It consists of 5 members with 5-year terms. The mayor appoints the chairperson, and the Board of Aldermen appoints 4 members, 1 from each ward. We have 4 wards in the city. The commission members, you all serve until your successors are appointed. If there's a vacancy due to resignation or otherwise, it's in that means like death or something, or somebody moves away, that the successor serves for the remainder of the term. The last few things here, commissioners have to be residents of the city, they serve without compensation, and cannot hold any other public office or be a candidate for office in the city while they're commissioners. And commissioners can be removed from office by the Board of Aldermen for cause for violating the requirements that we just talked about in terms of residency and compensation and other offices, or refusal to serve or malfeasance in office. That's a pretty standard thing in the municipal officials world. The last part that's in the code, 107.130, 107.140, is disclosure reports and filing of reports. This deals with disclosure requirements for disclosing and filing reports if an official or an employee is doing business with the city, owns businesses, and so on, and filing of personal financial disclosure reports with the city and requires the filing of personal financial disclosure reports with the city and the Missouri Ethics Commission. I'm not going to go through all of that unless you guys really want me to, because I don't think it's necessary at this point. It's sort of a separate process. It is in the Code of Ethics. It does all apply here, but it's not an issue with anything we have going on right now. So if we need to come back and go through that at some point, I'm happy to do that, but I prefer to not go through all of that. That's okay. That section, by the way, that information is the same thing every city adopts in Missouri, because if you don't adopt it, you have to follow the state statutory requirements, which are not very pleasant to deal with. So every city, on the advice of the Missouri Municipal League, follows those requirements. They're pretty standard stuff.
I didn't hear any objections.
Okay. At this point, that's what the Code of Ethics is, the Ethics Commission. Any questions on that before we jump into the Sunshine Law?
Any questions?
Question. Commissioner being a resident and serving another committee, not a political office, committee, is that disqualifying?
I think it said, let's see. Residents of the city shall serve without compensation, but okay. No members of the commission shall hold any other public office or be a candidate for the same in Parkville. I read that to mean
Be any elected office.
Elected office.
Yeah.
That's where you would be a candidate.
One question I have as far as compensation, I'm assuming that it's be out of bounds for employees to donate to political campaigns, put signs in yards, those types of things.
Honestly, I don't know what the city's policy is on that. It's generally a good idea not to do that.
I was wondering if that would be an example of a potential.
Yeah, I think it could raise that issue. It could generate a complaint, and the employee could find themselves here in front of you. So, in the cities I work with, that's most people avoid doing that, whether it specifically says that or not. Just good practice.
Thank you.
And a quick question, the disclosure has nothing to do with campaign financials, this is a personal disclosure?
No, it's different than the campaign, like a candidate for office campaign stuff. This is the information just about your personal finances that you have to disclose. And what they're trying to do there is, it's like, hey, if somebody's doing business with the city or has been doing business with the city, it needs to be reported. Otherwise, how would anybody know that an official's doing business with the city? And then it gets into some of the long section of this has to do actually with candidates, so that when someone signs up for office, and Melissa deals with this as a city clerk, they have to fill out I think it's a personal financial disclosure form to disclose what businesses they own. So then someone could look and say, oh, does the city do business with that candidate's company? That's kind of what it's policing. And all of that goes through the Missouri Ethics Commission, and the city gets a copy of it. So they're kind of the enforcement agent on that thing. But it's good they included it in our code of ethics because it is an ethical issue, you know, that we comply with. So that's how that works. But it doesn't deal with campaigns or anything like that. That's all Missouri Ethics Commission stuff. Okay, well, let's run through the Sunshine Law. I know some of you may be familiar with some of this, but we'll walk through it. I've got for you, it's actually a presentation I've done before over the years many times on the Missouri Sunshine Law. And it's just a kind of general overview so you have an idea. I want to make sure you all know about the parts in particular that affect you directly. That's the main goal. But you need to, it's good to understand the overall process and how it works. So first thing is who's subject to the Sunshine Law? Well, it's public governmental bodies, committees, boards and commissions, advisory committees, and what are called quasi-public governmental bodies. This one applies to you because you are an officially established commission of the city, so you fit within the scope of the Sunshine Law. So what is subject to the Sunshine Law? All meetings, records, votes, actions, and deliberations of a public governmental body. Again, you're a public governmental body. You fit within that definition because you're a commission. It says shall be open to the public except as specifically provided by law. And there's some provisions in here for when things are effectively closed records or closed meetings. So what is a public meeting? It's any meeting of a public governmental body in which public business is discussed, decided, or public policies formulated, whether the meeting is conducted in person or by means of communication equipment. In other words, a few years ago, nobody really considered what that meant. Now we all know it means Zoom or one of those types of things, communications equipment. And for it to be a public meeting also, it has to be a quorum of the body. In your case, that's 3. You're a 5-member commission, even though we got some vacancies. A quorum of this body is 3, is all 3 of you. So if 3 of you get together and discuss ethics commission business, that's a public meeting, whenever you do that. So like it says, it includes conference calls, video conferences, internet chats, and of course being physically present. That's a public meeting. And again, it's got to be a quorum. And what it doesn't include, just so you know, there's case law on this, is not including informal gathering for social purposes where there's no intent to avoid the Sunshine Law. If you go to a Chamber of Commerce banquet and you're all 3 there, that's a quorum of the body, but you're not having a public meeting because you're not talking about ethics commission business. So that's specifically excluded. So Sunshine Law, what is public business? It says public business is all matters which relate in any way to the performance of the public governmental body's functions or the conduct of its business. Again, for you all, having to do with business of the Ethics Commission. That's public business. Public records is broadly defined. It includes any record, whether written or electronically stored, retained by or of any public governmental body, including reports prepared by consultants for a body, for example, paid for, and that's paid for in whole or part by public funds. So emails that are sent that the city is sending to you, for example, are retained by the city. Those are public records. If you send an email back to the city, those are retained by the city, they're public records. Any report that you provide at the end of the day here is a public record because it's a document, whether it's electronic or whether it's on paper. Either way is a public record. So what's the procedure for having an open meeting, which is what we're doing tonight? The procedure that is required is to do what we did, which is provide notice. Notice requirement, which city clerk prepared, states the time, has to state the time, date, and place of the meeting, the tentative agenda. It has to be posted in a place easily accessible to the public and designated for the purpose of giving notice. And it has to be posted at least 24 hours in advance of the meeting, excluding weekends, holidays, when City Hall's closed. For example, your agenda of your meeting was posted on the door at City Hall where all of the meetings are posted. There's all kinds of agendas posted up there all the time, posted and taken down after the meeting. That's where it was posted. That meets the requirement. And then just, there are exceptions for notice requirements, unlikely to apply to you all, but just, if you can't meet the 24-hour notice requirement, for good cause shown, it's impossible and impractical, you give as much notice as you can, and then you state on the record what was the good cause. For example, I've had this happen in my time. A portion of the city gets hit by a tornado. The Board of Aldermen needs to meet immediately to deal with issues related to that, public safety and things like that. Request assistance from the state, all those kinds of things. You just say, we're having a meeting in 2 hours, we're putting it on our website, we're notifying the press, we're letting people ask everybody to pass it along. But we're meeting in 2 hours, and at the meeting you explain, here's why we didn't have time to do 24 hours notice here. It wasn't practical. Technical meetings, again, we talked about this, but if a body meets by, these are words from the sunshine of internet chat, internet message board, or other computer link, and you have to post a notice on the website and notify the public how to access that meeting. The terminology is a little dated in today's world, but for example, when we were going through all the COVID things, at the height of that, the city met, Board of Aldermen, Planning Commission, various boards met on Zoom, and that notice was posted, and there was always a link on there where the public could click on and participate or observe the meeting. So that's how we comply with that. I don't know that you all will be doing any of that, but that's out there. Emailing among members, this is an important issue. If a member emails with a quorum of the body, then you must send a copy of that message to the public body's office computer or to the custodian of records, who is the city clerk, Melissa, so that it becomes available for access as a public record. So in other words, if one of you emails to the other two, all three of you are on there right now. We don't have 5, but all 3 of you are on there. It needs to be CC'd to the city clerk. And that way it makes certain that it goes, she's a custodian of records. We make sure it's available for the public. Now, the next thing to make sure of, though, is emailing among members like I was just describing. You have to be very careful, because if an email goes out to a quorum and then people start responding to everyone and commenting and saying, well, I think this, I think that, it has the potential to be construed as a meeting, and 24-hour notice was given for that online meeting. So what we generally advise is anytime you'll get an email like with the agenda from the city clerk that goes to all of you, what we advise is don't reply all. If you have a question for the city clerk, just email her back directly. Don't reply to all. It's just, and it happens a lot. Innocently, people are trying to do anything wrong, but they hit reply to all, and it can create an issue. It doesn't necessarily mean it's a meeting, but it can be viewed that way if enough activities going on. Voting during an open meeting, you have to record all the votes in the minutes. That's what they're here for. And if we have roll call voting, which I don't know that you'll have any roll call voting, you might. There's only 3 of you now. If there's 5 of you, you don't really have to do roll call to know how each person voted. If you do a voice vote. But there are certain things, if you were to, for example, want to go into a closed or executive session and have the authority to do it, that has to be done by roll call vote, where the clerk will call your name. Actually, they'll call your roll at the beginning. So, closed meeting procedure, how you close a meeting in records. To close a meeting, it has to say on the agenda, we're going to have a closed meeting for this reason. You have to cite the statutory section. It has to be a motion made, and it should reference the section you're closing under. There needs to be an affirmative vote of a majority of the quorum to go in closed session. Excuse me. And that vote to go into closed session, and any votes that are taken in closed session, have to be by roll call, and the minutes have to be taken in closed session. There's a provision for objection to, just so you know this, to motion for closed session. So if you're on the board of this, like if you guys had a proper reason to go into closed session for something, legal advice from an attorney, and one of you, like if one of you says, I don't think this is proper. I don't think we should go into closed session. I think this should be done in open. You can state your objection to the motion that's made to go into closed session because you think it would violate the Sunshine Law. And the other members may say, well, we disagree with you, we're going ahead. And so the motion's made and there's a vote taken, and if you vote no, you basically have a safe harbor. You can still participate in the closed session, but if it's found to be improper, illegal, violating the Sunshine Law, you're not held, that individual's not held responsible. So doesn't typically happen, but it's out there. So what are the reasons you can go in have a closed meeting, records or votes? The one I listed there for you is the first one that pops up. What it is, the Sunshine Law, remember, says everything's presumed to be open. Records and meetings are all presumed to be open. But here's the exceptions to that rule, and it lists, forget how many there are now, 21 exceptions or something. Some of them are very specific and unique to, like the University of Missouri or the state legislature or things like that. But there's some general ones at the beginning. One of those, the very first one is you can be in a closed session or close your records related to legal actions, causes of action, or litigation, and confidential or privileged communications between a body or its representatives and its attorneys. So, for example, if you're doing something and there's a legal issue that you need attorney-client privileged advice on, you can notice it up that you need to go into closed session, pursuant to that section, that exception. You vote, you go into closed session, your attorney can provide you with legal advice, and you can ask questions, you can discuss it, get the advice, and then you adjourn from there and go back to your open meeting, or you don't have another meeting, whatever you're doing. So that's the only one I initially thought of that could ever even possibly apply here. Most of the rest of them, like the second one is real estate transactions. You're not going to be buying any real estate on the Ethics Commission. The third one deals with hiring, firing, disciplining of employees. You don't have employees, so you go down the list, all these other things. You're not competitively bidding projects or anything, so these things aren't likely to apply to you. But that's the one that could possibly apply to you all. So if you do go into closed session, though, under any of those sections, exceptions, there are limits on what you can discuss. It's only business that directly relates to the specific reason that you were closed. In other words, the example you were given, getting legal advice from your attorney on a specific matter. That's all you're allowed to talk about. You can't then stray into policy matters or unrelated issues, things like that. You're limited to what you were closed for by law. Last few things, the Sunshine Law requires that the city have a Sunshine Law policy, written policy regarding the release of information and all that. It establishes a custodian of records. The city has that. The city clerk is the custodian of records for the city. That includes the commission. So what else is your city clerk doing with all this stuff? She's keeping the record of the meeting, the journal of minutes. That includes the date. It's got to at least include the date, time, place, members present, members absent, and a record of any votes taken. Another thing that comes up with the city clerk is responding to records requests. If someone says, I want to request a copy of these XYZ records. She has to, the law says, act as soon as possible. At a minimum, has to respond within at the end of the third business day after a request is received. And if she needs more time, you just let the requester know why and how much time is needed, because some things maybe right here you can provide it, some things maybe off-site. If it's a paper document, maybe an off-site storage, for example. It's got to be retrieved, or sitting in a box and have to dig through it for 2 days to find it. Or, electronic things, if it's a broad request, that may require the city's IT person to search the city server for the requested records. So that doesn't happen immediately. But you are required, the clerk is required to let the person know why it can't get it done in 3 days and how much time is needed to get it done. And if a request is denied, you have to give a reason in writing. The only time when you might deny a request is if it's for a closed record, something like a employee's personnel file, for example, is a common. Sometimes those requests come in; those are closed records, like a performance evaluation or something like that. Last thing, just to hit on the Sunshine Law, is the city may charge for searching and copying records, and it's spelled out very specifically in the Sunshine Law. 10 cents a page for paper copies up to 9 by 14, and then hourly fee for duplicating time. Can't exceed the average hourly rate for clerical staff of the body. Research time, actual cost of research time, and got to produce the copies. Use employees that result in the lowest amount of charges for search, research, and duplication time. That's required by law. So that's the quick version of the Sunshine Law. And again, I really wanted to make sure you all were familiar with the parts about that apply to you in particular. Notice for meetings, your records are generally public unless there's an exception that they qualify for. The meetings are public unless there's an exception. But a lot of the mechanics about the notice of the formal meetings and all that, staff will work with you to make sure that's handled. So that's the Sunshine Law. So, any questions on that?
Quick question.
Sure.
You mentioned that the quorum was 3. Is it, there's 5 members of the committee, there's
Right.
3 sitting. Is it quorum 3 or 2?
The quorum is as I recall, it says a quorum is, it's, so you're a 5-member commission.
Is it, I guess the question is
Yeah.
it of the
Because of the
sitting
2
members or,
vacancies.
excuse me?
Because of the 2 vacancies, is what you're saying?
Yeah, if I email just one other person a question, is that,
Yeah, see, it's 3 because let's say you didn't make it tonight. There's no meeting. And the purpose of the quorum is that a quorum can take action. And what you don't want to have happen, what they don't want to have happen under the Sunshine Law is that less than a quorum they don't want to have happen is a quorum gets together without notice and takes action. So it's got to be 3 of you, because that 2 of you can't. If 2 of you were here, we wouldn't have a meeting right now. We've never been able to call it to order.
thank you.
So good question.
Not so much a question, based on that, very recently the city clerk set me up with a city email so that any communication will be carved amongst the group and the city clerk so that any requests come will be easy to retrieve and keep it identified. So I think that handles all the questions.
Okay.
Looks like, speaking of vacancies, the fifth bullet item is the vacancies on the commission and appointment issues. So if you please take us through that.
Sure. You currently have 2 vacancies. Your other 2 members both resigned prior to this. They were, of course, you're the chair. As we mentioned, we went through the code. The chair is appointed by the mayor. The Board of Aldermen appoints the members from the ward, and I believe the vacancies are in Ward 1 and 4. So the Board of Aldermen will need to take up filling those vacancies. There is no process in the Code of Ethics about how they go about doing that or what process they use. It's up to the Board of Aldermen as to how they do that.
I thought the board was supposed to recommend the mayor then appoints.
No, that's the general rule for city boards and commissions, but this one specifically says that the Board of Aldermen shall appoint, and the mayor shall appoint the chair. Now, I think what happened and maybe in the past, and there's anything wrong with this, but I know in the chair position, the mayor appointed, but the Board of Aldermen voted. It was on the consent agenda for approval. I don't think that was, looking back, it probably wasn't necessary, but that's how it was done. But on the Board of Aldermen appointments, there's no provision for the mayor. The mayor could suggest, a mayor, whoever it is, could suggest who they might like to see appointed, but for the ward positions, but it doesn't say, the Board of Aldermen can ignore that. It's the Board of Aldermen's decision, the Board of Aldermen alone, as to who to appoint and how they do it, what process they use.
Okay. So November 16th is the next Board of Aldermen meeting?
Yes, a week from tomorrow is the next Board of Aldermen meeting.
And the assumption that request to fill those spots are already on their agenda. There's nothing we need to, as a group, need to move forward to put that in motion.
I don't know that, we don't normally have like a request, or we don't normally just put something on the agenda like that. If you would like for them to fill the position, like for them to go ahead and do it, you can request that they do so.
Okay, so I guess that's the question, is that we need to.
It doesn't automatically show.
Because I think one of the resignations was very recent, so if we need to light the fuse on something, I guess that's a question. If we have a quorum, it would be appropriate for us to take that action of some a motion to request that vacancies in Ward 1 and 4 are pursued to recruit and get some more teammates up here to kind of help through that. So.
That's totally up to the commission. You may do that.
Okay. Well, would anyone like to make a motion like that?
I don't understand where it goes, but
Your motion
would just go to the Board of Aldermen?
Yes, I think what the chairman's saying is it would be the commission asking the Board of Aldermen to fill the positions as soon as possible, and it would be communicated through staff to the board.
Well, am I allowed to make motions, or can I just direct, if we just get head nods and direct the city clerk to move on that?
You're probably better to make a motion. And I don't think there's anything that prohibits you as a chairman from making a motion. I haven't seen anything.
Well, I make a motion that we request that the Board of Aldermen move towards filling vacancies in the Ethics Commission for Ward 1 and Ward 4, and would like a second.
I second the motion.
Any discussion? Aye. Okay, all those in favor? Aye.
Aye.
Looks like a unanimous request to move forward on filling those spots.
And were you and I also? Mr.
Yes, yes.
Just for the record.
Yes. Unanimous vote. Thank you. Next up, and the city attorney, please jump in if we get too far over our skis. But bullet number 6, the complaint regarding Mayor Nan Johnston. Subsection A is acknowledging the receipt of the complaints. Prior to this meeting, knowing that we have just taken the oath of office and trying to get the personnel identified in an attempt to keep things moving forward, As the chair, I did officially notice or serve notice to the mayor on the complaint itself. So that meant with the city clerk's assistant, since that the complaint has officially been forwarded to Mayor Johnston, so that was of the list that Chris took us through. That is something that has been officially acknowledged and moved forward. The second part is establishing a time frame for the mayor's response. That's something that I think that comes into if we choose, and again, it would be a motion that we would ask officially for the mayor to provide a response roughly 10 days from now.
That's what the reference are, is 10 days.
And so I think as far as
I suggest we make a motion that the mayor be notified she has 10 days to respond.
okay. Do we want to look at a calendar just to see, get a date specific on that? That'd be like November 22nd-ish.
Just to clarify, is it 10 days or 10 business days?
It just says 10 days. If you can, it says at least 10 days, so it's up to you. If you want to use business days, you
But
can do that.
it's already been delivered.
She has received it electronically to her address. Did I say that correct? Yeah. Okay. Yeah, so she has received it roughly a week ago.
As the 20th, I believe, of October.
Okay,
I believe.
so more than a week ago, so 10 days. Would the 20, I'm just thinking Monday into business, the 22nd, would that be an appropriate time frame?
I believe so.
I will be out of town.
Okay, so this is her, we don't necessarily
We
meet,
can do it
that's where she would have to, she would respond to us, correct? She would respond to us within 10 days. And I think the C kind of gets into what do we do next as far as meeting times and all. So let's, it sounds like we have a motion to request a response from the mayor with 10 days minimum, and November 22nd is a date we can put as the due date. Do we have a second?
I second the 10 days.
So we have a motion and a second on requesting response by November 20 into business on November 22nd to the complaint that was forwarded. Any further discussion? All those in favor say aye. Aye. Aye.
Aye.
Opposed? This is a unanimous. Anything you need from us? Is that clear enough of what?
Did you get what you needed, Bob? Okay, so Brian, motion.
Jerry made the motion. Gil seconded that we would request that a response to the complaint arrive no later than end of business November 22nd. Okay. And then C, the city attorney can help explain this, but due to the nature of the complaint and the breadth of the complaint, including our spots, city staff spots, there has been advice that we should seek specific counsel just for us before we do more, before we really take action and those types of things. And for us to obtain that, we would need to request to the Board of Aldermen at their next meeting the approval to seek outside counsel, because there could be potentially conflict of interest between the city attorney.
Yeah, let me just for the record, let me just walk through that real quick. You know, obviously we talked about this when we went through the code, but it says the commission may call upon the city attorney and some others, and it says to assist in an investigation or may utilize outside counsel if it is reasonable and necessary to properly complete its work. So obviously, given the nature of the complaint that you all have, I think you're probably going to need legal advice on some of the issues and assistance when you begin going through the complaint and dealing with that, however you're going to deal with it. My role as a city attorney is to advise the Board of Aldermen when whatever action you end up with, advisory opinion, recommendation, comes to them. And so, as a result, sort of creates a conflict situation for me to be advising you about specifics on how you deal with the complaint, when I'm going to be advising the board of Aldermen on the same issue, and they may have a different view on some of these things. And that's why I think this is in the code. So my view is the board, and the law is the Board of Aldermen has to be the one to retain legal counsel by ordinance. And so the suggestion was to have you, again, do another motion that this time that just requests, as the code allows, request the Board of Aldermen to authorize or provide outside counsel to you to assist you in the matters related to the complaint.
So mechanically, November 16th, if that motion went to the Board of Aldermen and they give the green light, after that date, there would be some form of selection of an independent counsel that could talk to us about any conflict concerns,
Right.
kind of help guide us in the next steps, knowing that the response will be to us by the 22nd, and then we would determine based on it. We would do something after we've met with counsel on what exactly we do and how we do it.
Yes, I meant to say this earlier. I was okay, and I'm okay doing what we're doing tonight with me advising, because most of what we're doing is just talking about the procedures.
Keeping the ball moving up.
And I do serve as counsel to the different boards and commissions the city has. But this is a unique one because part of what you may end up doing is some sort of investigation and hearing. That's a little different than what we see in other areas. So it creates the possibility of there being some sort of conflict. And we don't want to have anything like that, call into question the objectivity of what you're doing. But I meant to say, I'm okay doing what we're doing tonight. But yes, my view is just as you indicated, after outside counsel's been provided to you, I would assume you would want to talk with them about the process, about some specifics of the complaint, whatever you feel like you need to consult with them. There's conflict issues raised in there with you all. You need to get their advice, not mine. You need to get their advice as to whether any of you have a conflict, things like that. So I think you're correct. That's the timeline.
Okay, fine. I mean, it sounds like these are things that are requested. I mean, it may sound, well, folks say, it sounds like that's going to take longer. I think even doing that, the intention is to get there sooner than later and keep moving and keep working on this.
Yeah, that's why we actually went ahead and did this tonight, structured it this way so we can keep things moving instead of just saying, oh, well, you need to get outside counsel, we need to wait another week, because we know, I think everyone wants to get this process moving and resolved in a timely manner. And so we're trying to expedite it a little bit by doing this.
Does that require a motion to request counsel?
I think it'd probably be best because, as with the other motion you made,
About the vacancies.
Oh, the vacancies, right. We'll be able to report those things in the Alderman before the next meeting, or as part of the next meeting, that the Ethics Commission has requested these two things. So then they can take those up if they want to at the next meeting.
Well, I will make a motion to pursuant to the guidelines to request at the next Board of Aldermen meeting that independent outside counsel be retained for this commission.
And I'll second that motion.
Any questions or discussion? Seeing none, all those approving say aye.
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 Opposed? Motion is carries unanimously. So that completes section 6, and so other business on 7. I think we talked around this, but I just want to make, so timing for next meeting, I think our interest is as soon as possible. I think the assumption is receiving the green light from the November 16th council or Board of Aldermen meeting, being able for us to meet, whether we meet our new teammates, whether we meet with an attorney at that time to get us moving. When the complaint shows up the 22nd, based on all of those things happening, we would we would set a date in the future. No, we got Thanksgiving and various things, but is that something, behind the scenes, we just work with the city clerk as the chair?
Yes.
So how, and this is a question not very familiar, first night stuff, how do we communicate? Do we just communicate that with just a meeting notice itself? Is there does the city have a social media account that broadcasts where we're at, or a status report? How do folks know where we're at unless they're really looking for it?
We haven't really talked about, standard, we usually post the agendas on the website and at the door here is required, at the door is required.
So an official meeting notice, but as far as like an update email or an update, is that thing, knowing that this doesn't meet all the time, but how do we give a progress report between, if someone's wondering, what are we doing now?
Usually they'll ask me and I can, as a clerk, I answer. I don't think we have ever done anything where we post updates on, we can't just, instances where we've done that,
Okay. Well, I'm not trying to complicate. I'm just saying there's a lot of, seems like a lot of things, a lot of yeah. We have to, several things have to happen before we can actually go to work. And if it's a meeting notice, that's one thing, but we'd be interested in exploring what just updates, progress reports can be done in between meetings. Would be something I'd be interested in exploring.
And one other thing that typically happens too is our aldermen, some of our aldermen are very good about, at the next Board of Aldermen meeting, at the end of the meeting, they have reports, and that a lot of times someone will say, the Ethics Commission met last week, here's what they did, here's what they stated their plan and process is, things like that.
Do I need to do that, be there to do that?
No, you don't have to. Usually we have aldermen that do that. They'll want to know what happened tonight, and then they'll report on it next Tuesday. But, there may be, the clerk is correct, she gets requests pretty frequently, like the next day, about what happened and what's the next step, what did the commission do. And so it typically gets out there pretty quickly from what we've seen. But it officially will be done generally, unofficially done by an alderman in a report in the Board of Aldermen. They're pretty good about doing that, making sure the public knows.
Okay, and so specifically on 7 then, a time for the next meeting, we do not have a specific time, date in mind. That is to be determined. Yeah. So other than that, for the record, is that clear enough for the record that it's just to be determined? And, Chris, if you could, I know there's some hands kind of raising in the back, knowing that we still have not met with council. Can you kind of explain versus other public meetings, whether we have comments? What are the rules in regards to the Ethics Commission, since that's a little different? Could you explain that to the group?
The meeting this is actually a business meeting of the commission, so there is no requirement for public comments in the meeting. It's up to you if you want to allow comments or questions. That you as a commission always have the option to do that. I think you have to, again, I'm not going to advise you on a complaint, all that stuff, but because it involves a complaint, I would recommend you be careful about responding in any way to anything that has to do with the pending complaint.